We just went through substantive due process and procedural due process. What do those have to do with equal protection? That's right, nothing. Equal protection is going to be half of all con law questions on the MBE. So it's worth taking a look at the text of the 14th Amendment. The 14th Amendment reads, "No state shall make or enforce any law which shall abridge the one, privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws." So the 14th Amendment Equal Protection Clause essentially states that all laws must treat similarly situated people in the same manner. So what does equal protection have to do with due process? Nothing. Equal protection applies when the government does what? Treats different classes of people differently. Whereas substantive due process is looking at, that's right, whether there is a burden on a fundamental right, and procedural due process is looking to see if if the government's depriving someone of a life, liberty, or property interest. We look to how much process is due. Equal protection. The government is doing what? Treating different classes of people differently. So we have a 4-step analysis here. Step 1, how is the government treating people unequally? Step 2, what level of scrutiny do we apply? Okay, so step 1, how is the government treating people unequally? How is the government treating different classes of people differently? Fact specific. Step 2, what level of scrutiny do we apply to that class? So we have suspect classes, quasi-suspect, and everybody else. So if the government is discriminating against a suspect class, like race, ethnicity, religion, or national origin, what level of scrutiny applies? That's right, strict scrutiny. The government must show that the discrimination is narrowly tailored to further a compelling governmental interest. So if we have a suspect class, we apply strict scrutiny. And who are our suspect classes? There are 4. 1, race. 2, ethnicity. 3, national origin. And 4, religion. Suspect class, strict scrutiny. And what are our 4 suspect classes? 1, race. 2, that's right, ethnicity. 3, that's right, national origin. And 4, that's right, religion. Okay, now we get to our quasi-suspect class, gender and illegitimacy, treating illegitimate children differently because they are non-marital children. This gets, guess what? Intermediate scrutiny. The government's burden is to show that there is a substantial government interest. It's substantially related to an important governmental interest. Intermediate scrutiny. Government must show law is substantially related to an important governmental interest. What's our first intermediate scrutiny case? That's right. Thank you, Ruth Bader Ginsburg. It's Craig versus Boren. And Ruth also gave us our standard for gender discrimination. There must be an exceedingly persuasive justification that comes to us from the VMI case, Virginia Military Institute. Okay, so we only have 2 quasi-suspect classes, gender and illegitimacy. For gender, we need an exceedingly persuasive justification. And what about non-marital children? Okay, non-marital children who are acknowledged or who have established paternity are due intermediate scrutiny for things like wrongful death benefits, inheritance, and government benefits. Okay, so our suspect classes are 1, race, 2, ethnicity, 3, national origin, and 4, religion. And they get, that's right, strict scrutiny. Whose burden? Government's burden to show that the law is narrowly tailored to a compelling governmental interest. High bar, it's rarely going to be upheld. A quasi-suspect class, gender, non-marital children. We get what kind of scrutiny? Intermediate. The government's burden is to show that the law is substantially related to an important governmental interest. And what's our first case? Thank you, Ruth. Craig versus Boren. Gender. In addition to our substantial important prong, we must show an exceedingly persuasive justification. VMI, Ruth Bader Ginsburg. And how about non-marital children? They have to have established paternity or been acknowledged, and if so, they may not be denied wrongful death benefits, inheritance rights, or government benefits under the intermediate scrutiny standard. Finally, so we've got our suspect classes, we've got our quasi-suspect classes, and then we've got everything else, which gets rational basis review. Who's the burden on? That's right, the challenger, to show that the law is not rationally related to a legitimate government interest. Okay, remember, rational basis review, the burden's on the challenger to show it's not rationally related to a legitimate governmental interest, and essentially it's going to be upheld unless the law is just completely arbitrary or irrational. Under rational basis review, the government's usually going to win. What's our great example here that we love so much? Massachusetts Board of Retirement versus Murgia, the age 50 mandatory retirement age for police officers. Okay, so step 1, how is the government treating people unequally? 2, what level of scrutiny do we apply? Then we get to how the law discriminates. Is it discriminatory on its face? Guess what we're going to apply? Strict scrutiny. One example, quotas or set-asides. Remember, University of California versus Bake, or however you pronounce it. Is the law facially neutral, but it has a discriminatory purpose and a discriminatory impact? Then the challenger has to produce evidence of that discriminatory purpose and discriminatory impact. Okay, step 1. How is, that's right, the government treating people unequally? Step 2. What level of scrutiny applies to this class? Suspect class is 1, race, 2, ethnicity, 3, national origin, and 4, religion. Quasi-suspect, that's right, gender and non-marital children. And everybody else, rational basis review. Okay, in steps 3 and 4, we ask, is the law discriminatory on its face? Then we apply strict scrutiny. Is it facially neutral, but it has a discriminatory purpose and a discriminatory impact? What do we need? Evidence thereof. Okay, that is equal protection. 4 steps. How is the government treating people unequally? What level of scrutiny applies to that class? Is the law discriminatory on its face? Is the law facially neutral but has a discriminatory purpose and a discriminatory impact? And the challenger needs to produce evidence. And that, my friends, is equal protection.